2 weeks will do?
Yes.
2 weeks.
My job day.
May I please your lordship? Lordship, I beg to mention item number 20, my lord. My lord, in this matter, I am seeking an adjournment today, my lord. As Mr. Asbot Thakur is not available today, my lord.
Item number?
Item number 20, my lord.
Motion.
Yes, my lord.
Place this matter again after 2 weeks on the date to be fixed by the registry on the prayer made on behalf of your name?
P.H. Kaur, my lord.
No?
P.H. Kaur.
On bid prayer made on behalf of Mr. Asbot Thakur.
Deeply obliged, my lord.
20. Nothing? Yes. Matter. Motion with the
Right, now 14, 15, 16, 17.
Yes, Mr. Sisti.
Yes.
What is there here left? Admittedly, they are BEd degree from Singhania and all. And the NCT has filed an affidavit in one of the cases,
Yes.
wherein it has said that we have not approved.
Approve that particular.
Yes, Mr. Bhuyan.
My lord, I just missed my lord.
No, it's okay, it's okay.
My lord,
I didn't, I
this
was
is a
looking for you,
matter.
I didn't see you.
My lord,
There is one affidavit of NCT in one of
My
the
lord,
cases
my lord.
wherein they have said they have not recognized.
my lord, the issue is.
If you have any problem, we'll take it out after some time.
No, my lord, we have, my lord. My lord, the issue is.
Hmm.
Other councils are not there. My lord, the issue regarding here, we have read that the Singhania University, my lord, which is a university operating in the state of Rajasthan.
Hmm.
And is a creation under the legislatures of the, my lord, Rajasthan Legislative.
No issue on that. No
My
issue on that.
My lord.
Only the issue they have raised, the NCT has raised BEd degrees. For BEd degree,
My
NCT has not granted recognition to them.
It is not required, my lord. My
One.
lord.
Two, you people have not taken leave from this
My lord.
and you have not gone there
My lord.
to undertake this course.
My lord.
Singhania University is a valid university, no dispute
lord.
on that.
My lord.
But they can't operate beyond their frontiers.
Territorial jurisdiction, my lord.
So,
Now, my lord, in what manner we have done the, my lord, qualification, my lord, that is a matter of examination by the department, my lord. That examination they have not done, and even the certificate which we are holding, my lord, that has not yet been cancelled. Now, my lord,
no, there is no issue of cancellation of your certificate. That certificate is with you, but it unfortunately has become an ornamental piece.
My lord.
It has become an ornamental piece. It's
No,
of
my
no
lord.
use.
My lord, with all respect, my lord, what I respectfully beg to submit before my
You are
lord.
appearing in all the matters?
UGC.
You are appearing in all the matters?
My lord, 14, 15 and
Where is that,
14,
which
16.
we'll take up? Which is the one you want us to take up?
My lord, item number 16 and 17 is connected, my lord.
Connected.
Seema Bakshi.
Hmm. Okay, we'll take up item number 16.
My lord, actually,
Okay. What is the grievance here?
my lord, the grievance is very limited, my lord, that our degree, though we are possessing the degree, we are not being allowed to, my lord, participate in the selection process, or our degree has not been taken into account. And when the recruitment process is
Okay,
initiated.
tell me, show me from your pleadings as to the manner in which you procured this degree. You pursued this degree.
My lord, my lord. In page 5, paragraph 3, in I am holding, my lord, WPC 5733. my lord. Paragraph 3, my lord.
Hmm. That is your details, During the petition also
In
completed
the
so
year
and so,
2000 by following the
due procedure of law.
law.
Now tell me what is that due procedure you follow?
My lord, my lord.
Where is your B.Ed degree here?
Lord, my B.Ed degree,
It's not annexed here.
honestly. My lord, may I pray, my lord, that all these matters may be taken up on the first week of March, my lord. Because, my lord, I am some underprepared today. One of my colleague is holding some materials, my lord. He is out of station, my lord.
On the prayer of Mr. A.R. Bhuiyan. Item number 14, 15, 16 and
No,
17.
15 I am not, my lord. 14, 16 and 17, my lord.
Anyway, it will go together.
My.
Tag matter.
On the prayer of Mr. A.R. Bhuiyan, learned counsel appearing for the petitioners, lists this matter again on 6/3/2024.
I'm appearing for
Only, Ms. P. Das,
2, 3, 4, 6.
secondary education.
No, your lordship, BTC.
Ms. P. Das, learned counsel appearing on behalf of Mr. P. Naik, standing counsel BTC is present, along with,
In 16R5.
Second.
I can, along with Mr.
J Ball.
Second.
J.
Ball.
J. Paul, learned counsel appearing for the
Secondary.
respondent number 5 in WPC number 3604/2020. एक order मान लेना sir.
Sir, please, sir, खबर है ना?
Okay.
मैंने कोई response.
Deeply obliged.
Money. Obliged, my lord.
Item number 18.
Not legal action, lordship, matter may kindly be taken up to some time.
Yes,
Lordship, matter may be taken kindly up to some time.
raise your voice.
Lordship, pass over for timely.
Ah.
Yes, sir.
All of this.
19.
Before rising of the court at any time.
May I proceed, Lordship?
Hmm.
Lordship, matter regarding dice foot number, Lordship.
19.
Lordship, case 24. I have a similar order, Lordship, earlier passed by your Lordship.
Where is that order of the
Case
27/7/2023?
18/10/2023, case 24, Lordship.
You have been ordered, but the order, the number has not been allotted.
Yes, Lordship. Earlier approached on Kochim Amtoli LP School, Lordship. And the name of the Kochim Amtoli LP School and Gangadhar Memorial LP School, Lordship, were recommended by the order dated 3rd January 2023, Lordship.
Just a moment, just a moment. Yes, what did you say?
Page 17, Lordship. Two schools' name were recommended, Lordship.
Hmm.
First, Kochim Amtoli LP School, Lordship, and
Hmm.
second, present petitioner, Lordship, Gangadhar M Memorial LP School, Lordship.
Hmm.
Earlier, Lordship, Kochim Amtoli LP School approached before this honorable court, and your Lordship passed the order, Lordship.
Okay, okay.
Only, Lordship, that order date is different. Earlier was 27/7/2023, and
The orders of this court. Earlier order of this court.
no, Lordship.
Same petition, earlier order is same.
Petitioner is different.
Gangadhar Memorial. 3765/2023, right? Page 19.
Yes, Lordship.
You want a similar order?
Yes, Lordship. Similar Lordship, which the Lordship has been passed, Lordship.
What is the date of your representation?
Date of representation, Lordship.
5/4,
Yes,
same day,
Lordship. Same date, Lordship.
27/7. What is this VME?
Yeah, Hansari means, Lord.
Oh, venture and is. Similar,
Masari.
dispose of it. एक बार खाली तुम्हारा एक पार्टी का नंबर मिल जाएगा. Your name?
Yes, Alam, Lordship.
Huh?
Yes, Alam.
Who is appearing for the Mr. Rabha? You are appearing for the.
I'm for the BTC, my lord. I think respondent number 282, no? Yes. No?
For 1 and 2, I am appearing, Lordship. The mission director, mission director was there.
3, 4, BTC. No, 4, 2,
একটু তুমি এটা বলে দিও, একটু কাহিনী করে।
This is elementary.
2, 3.
হ্যাঁ, discuss করো না।
And who is appearing, Mr. S.R. Rabha?
I am appearing for respondent number 2, 3, my lord. Mission Director Assistant.
I am for respondent number 4, 5, 6, 7.
No, it's no.
4, 2. 9, no? So, Parim, or to not in
इसके अंदर रख दें. Similar number. Dispose of.
Masari.
30.
30, 31, 32, similar.
ও তারপরে এইটা না এইটা তাহলে রনে করছে যে হেটি অ্যাপ্লাই করা বলি কইছে হেটি অ্যাপ্লাই করা বলি মনে করব এটা করা বলি কইছে
Can you go apply?
হেটি ওটা একটা ওকে এটা খালি নতুন কি অ্যাপ্লাই করে মনে দিব না আগে যদি আমি স্টাইল
Yes.
Your lordship dealt with this matter earlier.
Uh-huh.
Your lordship will kindly remember that interim order,
ডিভিশন বেঞ্চ
we had
অর্ডার
gone
করতে
to appeal, an appeal order passed.
Hmm.
That we may be allowed to,
They were allowed to participate.
yes, and their result will be kept in. Now, what has happened here? These people, they did not apply. Now, after appellate court's order, they are authorized to apply. Now, there were some persons who applied before 12, though they know they were disqualified. Now, my lord, since they have applied before the date. So they can. They may be, my lord, as per the Appellate Court's order. So their matter may be processed and kept in.
Means these petitioners have already applied.
Already before the date,
Okay.
12. The lordship remembers the date, 12/1.
12/2.
এটা মানে সবাই জানে।
Appellate order,
Page 529.
510 below.
Mr. Gohain, matter, which is the matter Mr. Bachchaji is taking up?
My lord, he is speaking, I don't remember my Meenakshi Kalita, my lord.
Meenakshi.
The same order is. Because of the number of petitioners we have.
Item 31.
Page 510.
Yes.
May I read it?
Hmm.
Having heard the learned counsel for the parties for quite some time, who we deem it appropriate to direct the state to provisionally allow the appellants to apply in the recruitment process initiated by the advertisement dated so and so, provided such application is filed offline before the last date of 12/2. However, the final result of the appellant shall be declared without the leave of the court. It is made clear that this interim order is only in respect of the appellants and shall not create any precedent. Lest this matter for admission after 8 weeks, we made it clear that pendency of the appeal shall not be a bar for the learned single judge to hear the writ petition on merit and pass final order. Now, my lord, by virtue of this order,
They
In
have
that-
been allowed.
allowed. In that case, but now we have applied much before that. That evidence your lordship will find Annexure 18 series.
It's just that.
Annexure 18 series.
These applications were accepted.
Yes, my lord,
Accepted.
yes, my lord. And the proof is also given, my lord. Proof was-
That your lordship will find at 417, that they have accepted.
এখন 283 আরম্ভ হয়েছে। Application দিয়ে।
Application মই করবো।
এখন notice-
19 series your lordship got. On the top of it, it is written.
Yes, I've got it. Yes, Mr. Mazumdar,
If the applications are there on record,
that will be processed but kept in seal cover,
Yes,
subject to outcome of
Yes,
discussion.
my lord.
yes.
Will not in process will create
Only two.
problem. They will be allowed to participate in the recruitment process and they will.
There is no interview
there
here.
is no.
There is no interview here. It's only the marks that they have to
They,
calculate.
they will have to consider these people's. The process may include the earlier part also. That is why it may be made clear.
Mr. Bachcha, you can take your seat. I'll just pass the order. You can have your seat.
Process will go.
Nothing more? Only this much is required.
Those who have submitted only there.
Heard Mr. A.K. Bachchaji, learned senior counsel, assisted by Mr. H. Puragohan, learned counsel appearing for the petition. Also heard Mr. R. Mojumdar, learned standing counsel, Department of School Education.
24. 2122.
You to apply for 2124.
Anybody appearing for the Union of India? Mr. Miss MS A Gayan,
December or
CGC. National Institute of Open School, nobody is there.
My lord, for NCT, we have served a copy of Mr. Alam yesterday. But for NIOS,
So can I record Mr. Alam's presence?
we have served a copy, we have a proof of.
Okay, no need. Taking it away. Issue notice, returnable 4 weeks. Mr. R. Mojumdar, Learned Standing Council, Department of School Education, accepts notice on behalf of respondent number 1 and 2. Ms. A. Gayan, Learned Standing Council, CGC, accepts notice on behalf of respondent number 3. Petitioner to serve notice upon respondent number 4, through Mr. A. Alam.
My lord,
A. Alam, Standing Council, NCTE. Full stop. No formal notice be issued. However, requisite extra copies of the petition be furnished to the learned, to the respective standing councils.
3500.
Also, petitioner to take steps for service of notice upon respondent number 5 by registered post with AD. Also, the petitioners in the present proceedings are all holders of 18-month diploma in 18-month diploma in elementary education. In pursuance to an advertisement dated, pursuant to the advertisements both dated 26/12/2023, the petitioners had uploaded their respective applications against the post so advertised. Such applications have been duly acknowledged by the respondents who have been submitted successfully. Also, it is to be noted that the said applications were uploaded by, were submitted by the petitioners online, full stop. It is the apprehension of the petitioners herein that in view of the prescription of qualification in the advertisement and the requirement therein of possessing a 2-year diploma in elementary education, the cases of the petitioners may not be considered on merits. Full stop. And accordingly, have instituted the present proceedings. Full stop. Subpara. In view of the fact that the petitioners have already submitted their applications online and the same having been acknowledged to be so successfully submitted, to have been successfully submitted by the respondents, comma. In the interim, it is directed that the cases of the petitioners shall be processed on merits in the manner required. Shall be processed on their respective merits as per the procedure to be followed for such recruitment in pursuance to the said advertisements dated 26/12/2023. However, the results of the petitioners shall not be declared by the respondents without leave of this court. Full stop. Subparagraph. List this matter along with WPC number 477/2024.
Highly obliged.
My lord, they will we will only process those applications where the acknowledgements are there and they have applied.
That's all.
But all
There
of
should
them
be
are
no-
there, my lord.
No, no,
Only
but
difficult
some
is
of
They
that
can give us a list, they can just give us a list, if,
Yes, ma'am.
while referent gives us a
Hey.
list of the petitioners
Can you
and their acknowledgement dates
Yes,
or
ma'am.
registration numbers.
Wait,
Yes, my lord.
लिखे लिखे
I do. If it is beyond this, sir. Ma'am, I will be-
नहीं उसका आगे में उसका आगे में
Yes,
in the interim it is directed that
The registration number to-
cases of the petitioners लिखो तो cases of the petitioners who have
500. Yes.
successfully uploaded their respective applications online
my lord.
Prior to.
and which have been acknowledged to
With
have been
registration
so uploaded by the respondents
Prior.
shall only be considered.
Yes, my lord.
With
Same
registration-
order.
Same order in the, I'll just,
Registration
Uh,
ID is what,
huh?
Lordship? Registration ID, they give one registration ID, that registration ID, Lordship will have, it will work out.
That will be in the.
That registration ID is the identification.
Okay.
my lord.
and were successfully uploaded and having received, हम कर देगा, तुम mark रखो, हम कर देगा. Having received the registration
ID,
ID.
my lord.
And
Mr. Buraga, you can do one thing.
My lord.
You can give him a list
Yes, my lord.
of the candidates along with their registration numbers.
Yes.
Will not put it in.
We will
You
give
can,
them the copies,
you can give him. No, no, sir, just give a list.
List of all the candidates with the acknowledgement and the registration ID, my lord. In
All those three matters, same order.
30, 31, 32, my lord.
30, 30, 31, 32. अभी तुम जाओ, मारो उसको, go.
We are highly obliged, my lord.
They are all going today, so I'll get it.
Anybody order one, two?
इसको भेज दो, विकास को. Mr. Pathak, madam, have a seat. No, no problem. Have a seat. Your item is 8073.
Yes, your lordship.
8073. sir. आइए कहाँ से नहीं 3095 no 1960 1960 to do आइए 1960 Where is your interim order? This order a 411, no?
411, 2009.
And this has been continued with,
This position continues.
shall continue.
I had submitted a short.
I know that. We are permitting them to proceed with that, but we will say that in view of the order dated so and so, in your case, without taking special leave from this court, your services will not be disturbed. That much only.
Very,
And we are not bringing you within the ambit of all those discussions.
very well.
Finally, we will say that this is the position. Anything more, man? Nothing?
No.
You may not get this order before Wednesday.
Very-
Because they'll go. He'll come back only on Wednesday there. So we are not here from next week.
Lordship.
Leha. The instant interlocutory application has been instituted by the Assam Public Service Commission. Bracketed, hereinafter referred to as the commission. As applicant, comma, in terms of the directions passed by this court, wide, it will give you a hello, wide order dated 18/11/22 passed in WPC number 6005 oblique 2021. Seeking leave of this court to publish the final select list with the final seeking leave to publish the final select list with regard to the posts of assistant professor bracketed non-technical and the post of librarian in the government engineering colleges of the state, advertised wide advertisement bearing number 5/05/2017, dated 25/5/2017. Also, the facts leading to the institution of the proceedings in WPC number 6005/2021 is noted herein below. Page 47, A to A. Page 48, B to B. এটা কোট করবো না লাগে, টেক্সট বলে লিখে দিব, B to B. Also, this court, while order dated 12/11/21, while issuing notice in WPC number 6005/2021, noticing the inconsistencies as pointed out by the petitioners in the screening process, in the selection process undertaken by the commission for the posts advertised, passed the following order. Pass the following directions with it. Page 50, C to C. Also, the passing of the said directions resulted in the commission postponing the scheduled interview and constituting an expert committee wide order dated 15/11/2021 to conduct an exhaustive scrutiny of the applications submitted by the candidates declared successful in the screening and language test already held to ascertain as to whether such candidates fulfilled the eligibility criteria as spelled out in the advertisement for the posts in question. Also, the expert committee accordingly undertook the said exercise and upon such scrutiny submitted its report and therein identified 41 numbers of candidates out of the 345 candidates clearing the said test to have not fulfilled the eligibility criteria as spelled out in the advertisement. Also, on receipt of the said report from the expert committee and after carrying out the due processing thereof, the commission approached this court by way of instituting I/C number 3095/2022, seeking the leave of this court to publish/notify 3095/2022 in WPC number 6005/2021. Seeking leave of this court to publish/notify a fresh list of eligible candidates for participation fresh list of eligible candidates, who have now been found to be eligible to participate in the viva voce section of the selection process. The said list as sought to be published pertain to both the posts of assistant professor technical, pertain to the posts, both posts of assistant professor technical, assistant professor non-technical, and the post of librarian in government engineering colleges of the state as advertised, while the advertisement dated 25/5/2017. Also, the said interlocutory application being ISC number 3095 of 2022 was taken up for consideration by this court. And while order dated 18/11/2022 passed in WPC number 6005/2021, the issues as raised in the said interlocutory application were given a due consideration. Also, this court, upon noticing the developments taking place in the matter after the passing of the order dated 12/11/2021 in WPC number 6005/2021 bracket or permitted the commission to publish notify a fresh list of eligible candidates for the next round of selection, that is the viva voce section. And also permitted the commission to hold interview with regard to such candidates. Full stop. The said leave was specifically granted by this court for the candidates appearing for the posts of assistant professor bracketed non-technical and the post of librarian in the government colleges of the state, advertised while the advertisement dated 25/5/2017. Also, it is to be noted here that with regard to the posts of assistant professor technical, wherein a similar exercise was also carried out, this court did not permit publication of the list prepared by the commission after the scrutiny by the expert committee. And in that, for the said posts, this court passed the following direction. Page 53, D to D. Page 53, D to D. So tomorrow here 1960 D to D. Also, it is to be mentioned that this court, while granting leave to the commission to proceed to publish the select list, publish the fresh list of candidates for the posts of assistant professor, technical, and librarian in the government colleges, non-technical, and librarian in the government engineering colleges of the state, had made it clear that the commission, after holding the viva voce interview, shall not declare the results without leave of this court. Full stop. It is in the said above premises that the instant interlocutory application has been instituted by the Commission seeking leave to publish the final select list in pursuance, final select list for the advertised posts of assistant professor, non-technical and librarian in the engineering colleges of the state, government engineering colleges of the state, pursuant to the interview held on 9/12/2022. Mr. T.J. Monto, learned senior counsel appearing for the commission, has submitted that the petitioners in WPC number 6005/2021 are all aspirants for the post of assistant professor bracketed technical as advertised technical in government engineering colleges of the state as advertised wide the advertisement dated 25/5/2017. Mr. Monto, 60052. By referring to the advertisement dated 25/5/2017 has stated that although different categories of posts were advertised through a single advertisement, comma, the recruitment to each of such category of posts so advertised would be an independent one, basing on the norms governing the norms governing such posts. Also, it is contended by Mr. Mohanto that the petitioners, having specifically applied for the posts of assistant professor technical, comma, they do not have a locus to assail the selection process for the posts of assistant professor non-technical as well as the post of librarian. And in the event the recruitment process is permitted to be completed in respect of the post other than the post wherein the petitioners are aspirants, comma, no prejudice would be caused to them in this connection. Also, Mr. Mohanto, by taking this court through the objections as raised by the opposite parties oblique writ petitioners in the present interlocutory application, has contended that the objections so raised pertain to the eligibility of two candidates who were shortlisted, who were found eligible for participation in the viva voce segment against the post of assistant professor non-technical on the ground of the residence of such candidates not being within the state. Also, it is the contention of Mr. Mohanto that the advertisement in question did not mandate any such requirement. And as such, the eligibility of the said candidates cannot be questioned on the ground of they not being residents of the state. Full stop. By contrast, Mr. D. Das, learned counsel, senior counsel, appearing for the opposite parties, writ petitioners, has submitted that the irregularities as pointed out in the advertisement cuts across the various posts as put up for selection, while the advertisement dated 25/5/2017, inasmuch as the commission had followed the same procedure for all the posts so put up for selection. Full stop. Mr. Das has referred to a has referred in this connection to the proceedings in WPC number 2089/2020 bracketed Orunov Kurt and 61 others versus the state of Assam and others, and has contended that in the said case, the issue is similar to the one raised in WPC number 6005/2021, and the said case, and this court, upon hearing the parties, a coordinate bench of this court, upon hearing the parties to the proceedings, has reserved its judgment. Full stop. Mr. Das, learned senior counsel, submits that the decision that would be rendered in the case of Orunov Kurt bracketed Supra would have a bearing in the issues arising in the present proceedings, and as such has required this court to defer the consideration of the present interlocutory application till the judgment in the said case is delivered by the coordinate bench of this court. Also, Mr. Das further contends that the commission, while preparing the list after the recommendations of the expert committee as noted above, had not maintained the ratio that is required to be followed for shortlisting of candidates for the viva voce component of the selection process. Also, it is the apprehension of Mr. Das that in the event this court permits the commission to proceed with the publication of the final list with the said inconsistencies, that would have a bearing on the selection process under challenge in the proceedings of WPC number 6005/2021 pertaining to the posts of assistant professor technical. Also, Mr. Das, senior counsel, further submits that the commission, in ignoring the procedure as laid down by the competent authorities in the matter of recruitment to posts similarly placed like that involved in the present proceedings, have permitted persons to appear in the selection process without requiring them to have a permanent residency certificate issued by a competent authority of the state. Mr. Das points out to the case of two of such candidates who have now been permitted to appear in the viva voce component of the viva voce component held for the post of assistant professor, non-technical, and have contended that the said two candidates are not residents, permanent residents of the state, and as such, they are not eligible to participate in the said selection process. It is the contention of Mr. Das that in the event such an irregularity is permitted to stand on record by this court, the same would cause prejudice to the writ petitioners when the process of selection in their cases are carried out by the commission, inasmuch as the same procedure would also be followed therein. First, basing on the said premises, Mr. Das requires that this court may be pleased to reject the interlocutory application and defer the consideration in the writ proceedings till the judgment in the case of Arnav Kaur is delivered by the coordinate bench of this court. Also, rejoining his submissions, Mr. Mohanto submits that the grounds as raised by the opposite party, writ petitioners, have to be understood in the context of the challenge as presented by them in the writ proceedings. The petitioners not being aspirants of the post of the writ petitioners being aspirants only for the post of assistant professor technical, they would have no locus to challenge the recruitment process as held for the other posts advertised widely said advertisement. Mr. Monto submits that the ratio for calling candidates to the interview has been maintained in the present process and maintained in the present process as per the provisions of the Assam Public Service Commission bracketed conduct of business bracket overruled 2010 and has placed before this court a breakup with regard to the set position, with regard to the set position in relation to the various posts put up for advertisement. Also, with regard to the issue of candidates figuring in the list prepared by the Assam by the Commission for calling candidates for the viva voce component of the selection process, who are not residents of the state. Mr. Mohanto submits that the requirement of having a PRC for the purpose of participating in a selection process was already examined by this court in the case of purely Debnath versus State of Assam and others, bracket or Lihiba, WPC number 1262/2022, and in the case of Saurabh Shah versus State of Assam and others, WPC number 4809/2023, and this court had concluded that such a requirement of having a PRC to participate in a selection process is in violation of the provisions of Article 16 of the Constitution of India. And accordingly, the necessary, the decision of the authorities mandating the requirement, mandating incorporation of the provision of mandating incorporation of a provision requiring production of a PRC for candidates by candidates desirous to participate in selection process was interfered with. Full stop. Mr. Monto further submits that the posts of assistant professor non-technical as advertised were lying vacant for a long period of time, and the delay occasioning in filling up the said post, in addition to subjecting such colleges to lose their recognition, is also against the interest of the students studying therein. And as such, he submits that the posts, if not filled up at the earliest, would be against public interest. Also, in the above premises, Mr. Monto submits that these proceedings, the present interlocutory application requires to be allowed, granting the leave to the commission to publish the final select list in pursuance to the interview held on
9/12.
11,
9/12/2022.
11, 9,
9/12/2022.
9/12/2022.
22.
Full stop. For the posts of assistant professor non-technical and librarian in government colleges, government engineering colleges of the state. Full stop. At the outset, it is to be noted that this court, while proceeding to allow the commission to hold the viva voce test, viva voce for the posts of non-technical or librarian, while order dated
18/11/2022.
by order dated 18/11/2022, had noticed the submission of the counsel for the petitioner, learned senior counsel for the petitioner, that the petitioners therein had applied for only for the post of assistant professor technical as advertised by the advertisement dated 25/5/2017, and not for any other post advertised along with it. So, thereafter, this court had in details examined the process that was carried out by the commission to remove the inconsistencies as projected in the writ petition pertaining to the question of non-eligible candidates being allowed to take part in the selection processes, take part in various stages of the selection processes. And it was after noticing all such steps as taken by the commission in the matter that this court proceeded to allow the commission to advertise, to publish the final select list, to publish the fresh rectified list of candidates against the posts of assistant professor, non-technical and librarian for the purpose of allowing them to appear in the next segment, that is next segment of the selection process, that is viva voce, and further permitted the commission to hold such viva voce for the set categories of posts. Subpara. This court, as noticed herein above, had not permitted undertaking by the commission of a similar exercise in respect of the post of assistant professor, technical. It is also to be noted that the order dated 18/11/2022 has not been put to challenge by the petitioners, and the same continues to hold the field. This brings this court to consider the objection raised by the learned counsel for the opposite party respondents or petitioners that this coordinate bench of this court, having already heard the arguments of the parties in the case of Ornab Kaur Supra, wherein issues similar to the one arising in the present proceedings had also arisen, this court should defer further consideration in the present proceedings and await the decision of the coordinate bench of this court in the case of Ornab Kaur Supra. Also, the order dated 19/3/2020 passed by the coordinate bench of this court in the case of Ornab Kaur Supra was placed before this court, and on perusal of the same, it is seen that the petitioners therein were aspirants for the post as advertised by the advertisement dated 25/5/2017 in different polytechnics of the state. In the said case, no challenge was presented to no challenge was presented to the selection process as carried out for the posts of assistant professor technical and assistant professor non-technical. Full stop. In the considered view of this court, for the purpose of considering as to whether a leave as prayed for is to be granted to the commission or not, the proceedings in the case of Ornab Kaur bracketed Supra would be of no relevance at this stage. As to how the said proceedings would become relevant to the issues arising in the present proceedings is a matter to be considered by this court as and when such occasion arises in the future. Also, the other objection with regard to the fact, comma, of the fact of candidates who are not residents of the state being permitted to take part in the selection process as held for the post of assistant professor, non-technical, is concerned. No further deliberation is called for therein in view of the decisions of this court in the case of Pioli Devnath Supra and Saurabh Shah Supra. Further, no such condition being mandated in the advertisement dated 25/5/2017, it may not be open to the opposite party writ petitioners to raise such objections after having participated in the selection process by reckoning the conditionalities as put therein. This court cannot incorporate conditions in an advertisement inasmuch as such power is vested with the executive only. Also, another aspect which in this connection which is to be noticed is that the petitioners in the writ petition, that is WPC number 6005/2021, have also not prayed before this court for incorporation of such condition in the said advertisement. The objection as raised with regard to the non-maintenance of the requisite ratio for calling candidates for the posts now for the post against which interview has already been held by the commission is concerned, it is to be noted that the same would require a detailed hearing on the detailed hearing, and the same cannot be decided at the interlocutory stage. Be that as it may, it is also to be noted that no candidate has instituted any proceeding. But we noted that this court has not been apprised that any candidate who had missed out a chance to appear in the interview segment for the posts of assistant professor technical and or the post of librarian on account of the correct ratio not being applied by the commission for calling candidates to the viva voce had instituted any proceeding in this connection before this court. No proceeding on that connection, Mr. No proceeding. So in that view of the matter, this court is of the view that the said objection does not merit consideration insofar as the issue arising in the present interlocutory application is concerned. Full stop. Anything more, Mr. Montauk? Anything more to be dealt with? Nothing?
That's all, madam.
In view of the said conclusions arrived at, arrived at with regard to the objections raised by the opposite party writ petitioners in connection with the prayer made by the commission in the present interlocutory application, this court is of the view that the rights of the petitioners would not be violated in any manner in the event the recruitment process against the post of assistant professor, non-technical, and the post of librarian is permitted to be taken to its logical conclusion. As such, the commission is hereby permitted to publish the final merit list against the advertised posts of assistant professor, non-technical, and the post of librarian as existing in the state, in the government engineering colleges of the state. Full stop. That'll do. Full stop. However, it is to be however, this court requires the commission to inform the appointing authorities that the selection process involved with regard to the posts of assistant professor, non-technical, and the post of technical is presently sub judice before this court in WPC number 6005/2021 and other analogous matters, and require the appointing authority. Full stop. Full stop. Full stop. In the event the appointing authority decides to effect appointments from the select list as forwarded by the commission, the appointing authority is at liberty to do so. However, in the appointment orders so issued, it should be specifically full stop. In the appointment orders so issued, a clause to the effect that the appointment so effected is subject to the outcome of the proceedings in WPC number 6005/2021 and the other analogous matters being heard together with it is to be incorporated without fail. That'll do. So, at this stage, this court would like to deal with 80. Rahul Amin Raza, your case. At this stage, this court would like to deal with objection raised by Mr. K. Pathak, learned counsel appearing for the petitioners in WPC number 8073/2019 to the effect that in the event this court permits the authorities to take the selection process against the posts of assistant professor, non-technical, to its logical conclusion, the same would be contrary to the directions passed by this court in favor of the petitioners in WPC number 8073/2019. So, on perusal of the records of WPC number 8073/2019, it is seen that this court, while ordered it at 4/11/2019, had directed that till disposal of the said till consideration of the issues that was raised in the said proceedings, the services of the petitioners therein as guest faculty / part-time members in Barak Valley Engineering College at Karimganj should not be disturbed without specific leave of this court. Full stop. It is provided that in the event the selection process with regard to the posts of assistant professor non-technical is taken to its logical conclusions and appointments are made from the select list prepared by the commission. The services of the petitioners in WPC number 8073/2019 shall not be disturbed, and a status quo with regard to their such services shall be continued with till the authorities take file appropriate application before this court seeking leave to terminate the services of the petitioners in WPC number 8073/2019. With the above observations and directions, this interlocutory application stands disposed of. Apuni, ekini record.
My lord, so far as main case is concerned, my lord, it
Ah,
is also, my lord, it may,
WPC
my lord,
number WPC
end
number
of this month, my
6005
lord, first week
খালি
of
মেইন
March.
কেস কিটা লিখিব দে এতিয়া
Madam,
WPC নাম্বাৰ কিটা লিখিব তিনটা একেলগে লিখিব IA কিটা নালাগে what will happen to the other IA
my
that
lord.
IA
No, other area, my lord, in respect of, my lord, that is technical.
that
all
will be
that-
there
That will be there.
3095 or something 3095
That will be there. That is not
That
been
will be there.
disposed of, that will be there.
3095 to লিখি দিব লগত list this matters pleadings have been completed
My lord.
pleadings have been completed in the above noted writ proceedings and accordingly list this matters for admission hearing
Want to go
on
as early as possible. File within the. In respect of one, my lord, affidavit has to be filed within file.
okay
All-
Ovix, when do you want it you give me a date I'll fix it
First, midst of the March, my lord.
mid-March
March.
yes yes Mr.
By this time, please. you
Mr.
can
Doctor when will it be comfortable
12th March.
12th let us have it on 13th
My lord.
on 13/3/2024 also
In the meantime, pleadings will be extended.
in the meanwhile, the parties are at liberty to bring on record their respective pleadings, if any.
Diploma.
A big thing gone. I at dispose of 1960. 1960 to dispose. Baki at
Yes,
dispose
my
no
lord.
day.
1960 may be disposed of, my lord.
Careful day, no like to dispose
My lord, yes,
dispose na khani nibo.
yes,
It has happened with me.
my lord. Deeply obliged.
I think everything is covered
My lord.
in the simplest form I can.
My lord.
Oh, Maria, to me, my dear. আজি আৰু বেছি দিয়া মনো নাই Madam, if you both agree that if you get, I'll show the matters disposed today, but you will not get the copies before, uploaded copies before next Thursday or Friday.
Oh,
So I can't trouble them today because they are leaving and I'll be not here from tomorrow. But the copies would be uploaded by Thursday or Friday. I'll show it disposed of today.
yes.
Get a disposed the head. Get on video 5, 6, 7, 4, 4, 5, 6, 7.
No, my lord. 4, 5, 6.
4, 5, 6, sorry.
Yes.
4, 5, 6. Abo? You can apply for your certified copies so that there is no time, but by next Friday you will have it.
No problem.
Right? Get a move diddly hole. Upot khali note pa likhi dibo ne. Amon note ase ta bitor to bhalke sab. Okay,
Yes,
thank
I'll
you.
do
Same thing, I'll pass the orders. Only thing I'll give you a liberty to approach the authorities.
My lord. And authorities will consider our.
That's true.
Yes.
That's that. And, but again, if you want to go up on something is there, apply for a certificate copy. I'm running short because my people are going back today. So I can't trouble them. So I'll have to go there and dictate back. So this orders, you'll get it by Thursday, Friday next.
No issue.
You can make your apply for your certificate copies. I'm showing it disposed of today.
Deeply obliged.
Well, এইকেইটাও dispose দেখাই দিব, file কেইটা মোক without fail দি দিব দেই।
I'm
Next.
appearing for SSA, your lordship.
Okay,
My lord, in respect to item number 8, my lord, I bring some judgments, my lord. One, can I hand it over to?
yeah, please. Just give me a brief of what is the judgment for.
2007 4 SCC 207
2007 4 SCC.
207. Lordship will find the facts at paragraph number 2.
Hmm.
And
No, just give me the hang of it, that's all. What is the issue involved? What is the issue
yeah,
decided?
here, my lord, there are two sets of employees, my lord, have issue regarding payment of pension, my lord. Some sets of employees had given pension from the earlier date of.
What is the name of the case?
State of Karnataka versus Karnataka State Petal Sangha and another.
Who took it?
2007 4 SCC 207
Items
78.
7. 7 is the.
Okay, what do you want to highlight from this?
My lord, that similarly placed persons, my lord.
Oh, you want to say that there should be a parity between the persons who have been
Yes, my
considered?
lord.
That Shiksha Mitras and you.
And yes, my lord. Since there is no rebuttal from there.
Paragraphs?
At paragraph 2, lordship will find the facts. my
Facts,
lord.
yes.
And at paragraph 5, my lord.
RM Decca petitioner.
Right.
And the next one?
My lord, 2015 1 SCC 347. My lord, I'll rely on 2007 4 SCC, my lord.
This may be a bit dicey for you.
2000
State of UP.
State of UP, my lord. 2007 4 SCC, I'll rely on.
There's one beautiful paragraph here. Wait. I had used this case appearing from that side.
Yes.
Wait. There is a paragraph somewhere here. Okay, fine. Anything more?
No. Deeply obliged.
Take it out. Madam, you are appearing for the RSA. SSA.
SSA.
And who is appearing for the other state respondents? Who is appearing for the other state respondents?
1 to 3 I'll appear. 1 to 3.
Anything more to add, Mr. Mojumdar? We'll say that it's a policy decision of yours. They can approach you by way of an application with all the required materials. If so, you consider, but we will not issue a mandamus. We will. Take it up. Staple my item number. Good going. Service to good. Service to good. It is a supply. Supply. 7, 8. 7, 8. Yes, Mr. Mojumdar. Your Vartak, what is there to say?
My lord.
Yes, 9, 10, 11.
That matters pertaining to that removal, education certificate. We tried a lot to somehow get out of my Lord Justice Patel's judgment.
The appeal came up today, madam.
What happened?
Condonation of delay. There we should notice. Today the first time.
But
Notice.
I think we are bound to follow that. You will have the judgment. I tried to dictate, but I couldn't. He has dealt it in such a beautiful manner. Couldn't go.
One judgment, my lord, has not been taken into account in that. I'll be. That was the judgment of Sarfraz Khan, where also the division bench has held.
Our division bench.
Our division bench has held that things done prior to induction will not come under 11.
Give me that citation.
I'll give that, my lord. I'll give that judgment.
You can,
I forget
can give it to him.
Yes, my lord. It's a DB judgment.
No,
There
give it
the
to me.
case was-
I'm dictating that. I can incorporate.
Today, sir,
that.
my lord.
Oh.
There it was a case where he had filled in that recruitment rule form prior to recruitment regarding some police case.
Give me,
Also,
that will
it is prior.
be relevant because that's a gray area where I'm finding in this judgment. There is,
The honorable court only holds that it is not 11-1. It
I
could
was
be anything
totally
else.
against you. I was totally against you. I was totally against you. But after having read that judgment twice, I'm convinced that I have to follow it.
The procedure
Procedure.
follower is under CCS. That is it.
Lucky.
Like it is. But here, in the last two
If
pages
it was not a CISF or employee covered by those provisions, I would have put in something else there. Anyway, that is the beauty of this.
we come out somewhere, we
No, you have to
Track
be,
somewhere.
you have to keep yourself open always. And I loved it and I liked it. Because I had to convince myself that no, that judgment is true. I read it twice. And thereafter, I was convinced I'm bound to follow judicial discipline. But you're not entitled to a relief.
one thing that,
Yes,
no, my lord, here, lordships.
you just tell me after the decisions of the Supreme Court, what is
Yes.
left? That much only you tell me.
I'll just come to that part. Will not go too much.
Today I missed out on that. There is a latest judgment also.
Yes, I'll address all of them, my lord.
Just give me a line answer as to what remains. Then you start.
My lord, we'll just come to page 69. Page 69, my lord.
Hmm.
In the light of the settled legal 19 I'm reading. On a conspectus of the factual scenario noted above, the impugn directions by the High Court cannot be sustained.
Hmm.
They are set aside.
Hmm.
Now, what was the direction? The direction was to go by a scheme 222. Before parting with the case, we are constrained to observe that the conduct of the appellants in engaging casual workers for a period of less than 6 months and giving them artificial breaks,
Hmm.
so as to ensure that they do not become eligible.
That is on the facts of that case.
our case, Vartak Labor Union case. This is Vartak Labor Union case only. My lordship will
You're
not
reading
part-
para page?
I'm reading page 16, page 69. Lordship will find, this is page 60, Union of India versus Vartak Labor Union.
Before parting, we are constrained to observe so and so, so and so. Hmm.
Appellants in engaging casual workers for a period of less than 6 months and giving them artificial breaks so as to ensure that they do not become eligible for permanent status as evidence from the additional affidavit dated 23rd April does not behove the Union of India and its instrumentalities, which are supposed to be model employers. With anguish, we extract the 11th paragraph of the same affidavit. Now, para 21. Therefore, in the facts and circumstances of the instant case where members of the respondent union, where members of the respondent union have been employed in terms of regulations and have been consistently engaged in service for the past 30 to 40 years, of course, with short breaks, we feel the Union of India would consider enacting an appropriate regulation scheme for absorption and regularization of the service of the casual workers engaged by Bureau for execution of its ongoing projects. In the final analysis, the appeals are allowed and the impugn judgments are set aside. Now, Lordship would kindly have the next page, page 72.
That is that.
That scheme, they say that BRO, all the works are seasonal. We have 90,000 casual employees and we cannot frame a scheme. what the Supreme Court says regarding
Now,
that scheme
now,
is-
Mr. Wilgood.
Madam.
You are relying on that last paragraph. Wherein a
Liberty was-
desire was expressed by the Supreme Court that the government may. You filed a contempt.
Yes.
That contempt was dismissed.
We'll come to how it was dismissed. My lordship will kindly have that scheme. Now lordship
Forget
comes
that
to
scheme.
page-
That scheme is being considered in the subsequent cases.
No.
Yes, I'll show that. You come.
Page 74.
Where is that latest judgment? After this, there is a judgment of the Supreme Court today somehow.
Yes.
The day I brought it today, I don't have it.
It is there. It is there.
You have it?
I have it. I have copies.
Just check up there. There is a reference for this.
Move file to the. Wrong. Yes. Yes, lordship. The latest judgment. Yeah.
I think it was,
My lord,
I had it on record.
I have given it. My lord, only one, my lord, indulgence, my lord. Judgment I have supplied. Now, my lord, lordships kindly have the orders passed in the
Huh.
contempt petition.
Civil appeal number 3146.
My lord,
Yes.
that is the one I'm
so,
saying.
mm, Yes.
Lordship will kindly have page 76 of the content of the writ petition for approval. Page 76 of the.
Mm.
Para 5. In
If
view
they
of
to
the above-
question the correctness of otherwise of the endorsement dated 7/9/2020 before an appropriate forum. Right, now
Now,
come
my
to
lord-
this.
No, I'll come to that. I'll come to that. My lord, lordship will just. Now, my lord, what happens is that the BRO as such is an organization which takes up construction work through GRAFE and is a part of the Indian Armed Forces. That is, there is no denial.
Now, Mr. Mazumdar,
My lord,
take it, assume that we are with you. We accept your thing,
my lord.
that there has to be something done. It will be prospective, it cannot be retrospective.
Could be, my lord.
How many of your employees are now presently
Seven.
available?
Yes, sir.
They all are serving.
Yes, interim orders of this court, those who have reached the age of retirement have gone out. Others might have done the interim orders of the
But
court. are
maximum
serving.
might have gone out on retirement,
My
though
lord,
they
I
will
think
not be
six-
entitled.
six or seven. That is the whole issue, my lord. If we take it up to be a big CPL part that we are asking a regularization form for, my entire case falls. When I speak of one of the establishments or two or three of the establishments which are permanent in nature, where CPL engaged is not temporary or locally picked up on a monthly or a 6 monthly basis. There.
You
the
mean to say
difference-
that this workforce is like our muster?
No, it's not a workforce that I'm talking of. That is the whole issue. I'm not talking of a workforce.
Who are you?
PRO is a big
No,
organization.
no, you're this people, who are they?
We are casual employees, as they call us, working in 3 establishments of the BRO, which are not temporary and not seasonal. And our claim is that they consider our cases apart from those establishments which are seasonal and temporary. That is our case. Lordships, if I'm not being able to, lordships will kindly have the paragraph number where I have tried to, my lord, para 21, my lord, of my writ petition, my lord, that explains to some extent, my lord, what I'm trying to project before this court and why that 7/6 memorandum is what I'm challenging, my lord. Para 21 and 22. Para 22.
Para 21 again, same thing, 1 day break.
No, 1 day break is what the Supreme Court's, we are not on the 1 day break or not the 1 day break. What
But
we are trying to say,
Supreme Court. Okay, Supreme Court, there are two parts.
2 points. That is what I'm saying, trying to say. What I'm trying to say is, when the BRO makes.
Mr. Bora, he is taking me down the lane. You be careful.
Yes.
You be very, very alert.
My lord, what happens
Yes.
is that, my lord, before I go to this, let me explain it to
He
some
is
extent.
taking me in a circuitous manner, so I get confused. Pass
No.
on that. So you be careful. You point out.
My lord, what I am trying to emphasize.
I got it.
is-
Okay, let's see what their
When the
reply is
PR
to 21.
Lordship will come to 6 first, para 6. Let me go straight, my lord, para 6.
Hmm.
It is stated that due to the large scale exploitation of mechanical equipments held in BRO, two base workshops, one at Pathankot and the other at Tejpur are established during 1961 to provide base repair facilities.
Hmm.
These are respectively deemed to be the Western Base Workshop and the Eastern Base Workshop,
Hmm.
based on their geographical location. The role of the base workshops are to overhaul vehicles, equipments, plants, engines of all projects of the Eastern sector, provide full repair cover to all local units and transit vehicles, carrying out repair and major minor exercise and fabrication. Modifications as ordered by the headquarters, Director General Border Roads from time to time. They receive account and issue repairable overhaul whole vehicles, equipments, engines to carry out defects. Investigation of prematurely failed vehicle equipment and plants. The said Eastern Base Workshop is thus a permanent establishment, and the members of the petitioner union in the said workshop have been continuously employed in the workshop, albeit with 1 day gap in every 6 months for the past around 30 years or so.
Pen drive to আনিছো না, ইয়ারটা থাকবে তারপর।
So, my lord, the BRO has two types of institutes within themselves. Two types of work. One, when they build a road at the border, they hire locally, fire locally, use whatever they need to use there locally, and it ends there. Those are also CPL. Here is a workshop which they admit has been existing at the same place with the same staff. Persons differ, but the same post, the same staff, the same work condition for the last 30 years from 1961. Now we are 20 years more down the lane. When they say that this is a temporary establishment where we are doing hiring and firing.
Okay, fine. Show
That
me
is my
show me
case.
the latest decision.
Latest decision, Lordship will not complete. What the now before I read the latest decision, let me place my what has happened. In this case, the Honorable High Court Division Bench had said these schemes you immediately implement. What the Supreme Court has said already in the Vatak labor case, schemes will not be dictated by the court, covered, set aside. But how does it decide my issue? Whether 7/6/2014 by
Okay,
clubbing.
come to para 13 of your.
My lord.
The latest case, All India Trade Union.
Yes, yes,
Congress.
I'm there. Para 30.
Hmm.
There was also a case of the Union of Workers, namely Vatak Labor Union, who claimed a relief of regularization from the service of the casual workers.
Casual workers.
We also casual workers.
That's
We
what I'm
admit
saying.
it.
Huh. Who were
We were
working.
working in BRO for a considerable time in construction activities undertaken.
You
by
are
the-
not in construction, you are in maintenance.
That is the whole thing. When the maintenance of permanent establishment comes into play, I have gone through the entire pleadings, all the judgments of the Honorable Supreme Court. Not one word I could find that we are claiming to be.
The
At any
Supreme
point of
Court
time,
did
construction
not,
activity.
that is a distinction you are trying to make. Supreme Court did not proceed in the matter in that line. It proceeded with the concept of a casual employee.
Only.
Finally, while disposing of the matter, it noticed the fact. But that was not the basis of that judgment.
Yes.
Because if you come to this trade union,
These trade unions, they admit, even in item number 8, they are admitting that they're temporary seasonal workers. Our case is that when you take up the cases of casual employees for consideration for regularization, you have to draw a distinction between those establishments where the work is permanent and continuing in nature for the last 30 years, and those work projects where you work for 1.5 years, 2 years, or 3 years, finish the
just a
project and
moment,
go
there
on.
is a thing here somewhere for that 6-month thing. Somewhere I found it.
Yes, yes. That 6 month is there. That Lordship will find.
Yes, para 6.
Para 6.
So here it does not talk about the seasonal worker. it talks about a class of workers working continuously in a project,
In a project.
but 6 months break, then again. Seasonal would be that they are there for around 6 months. Thereafter, when the rains come, flood come, they are not taken. But here, that is not the case. Be careful. Just which point that out.
Para 6.
Para 6.
Respondent trade unions filed a repetition in the High Court of Uttarakhand and Nainital against the applicants claiming a relief for regularization of the casual workers who, according to the respondent repetitioners, are working for a considerable long period in one project. In one project.
In one project. So it
Undertaken
does not
by the
say
BRO.
seasonal.
That is where I am drawing the distinction, my lord. This Vartak labor in this project Vartak consists of one
No,
establishment. which is permanent.
you're that saying, I understand. Project Vartak, project, then there is one more. In the northeastern region, we have Project Vartak and one more is there. Arunachal.
That Arunachal case is item 8.
Huh?
Item 8 is the Arunachal case. I'm not there, but.
That
item
is,
8
what is
the-
that project?
That will be,
There is a project. Yes, Mr. Bora, what is that project in Arunachal?
That is not known to me, Your Lordships.
that is project.
I have
I
been
did not
dealing
go through
this,
that
with this, now I don't remember it. What a bad.
Seva.
In, out,
Brahmang, if I'm not wrong.
Huh?
Brahmang is what my friend said.
what?
Brahmang. No, it is project Setu.
Vartak is there. So it is identified by a project. And the Supreme
This-
Court herein
This,
does not use any other word, project.
what lordships will find is, my entire case is that this project, this Vartak is where within that project Vartak, that campus, this eastern based workshop is located.
No, it's a part of that project.
No, that is what I'm trying to emphasize, lordship. Kindly see again paragraph.
Okay, let us give you that benefit.
My lord. My claim is not for regularization. My claim is a challenge to the
You come to page 70
of the
of your petition.
madam. Yes,
You are trying to now distinguish between persons, you say were in the project in a seasonal manner, and the persons who are there in the project, like a workshop or like yours, where you are working, who are there all along the year, all around the year.
yes.
Now come to page 70, quoted portion.
Put it
Page 70, quoted portion.
70.
70. Internal
I'm so sorry.
para, just above
Yes,
para 21 of that.
Yes, relying upon the provisions contained in paragraph 501 to 508 of the regulation, it was contended that the casual laborers are mustered on daily or monthly basis. If on monthly rates, the period of engagement, it shall be for minimum period. You can just have one look, 2 lines above that. With anguish, we extract the relevant paragraph.
Forget it. You, we
It is a fact
we
that-
also have anguish.
My lord, this is in the affidavit that they are stating.
I'm saying that
It is a
was,
fact that the large number of casual laborers have worked with Project Vartak for number of years, but the period of engagement at no stage has existed for more than 6 months at a time. Their services are terminated before completion of 6 months, and as per requirement, they are recruited afresh by publishing Part 2 order by mustering unit. Due to the fact that they have not been able to continuous engagement for more than 6 months, they do not get the status of a permanent employee, and accordingly, as per paragraph 503 of the regulation referred to above, the casual person are not.
okay.
Madam,
Now here,
what-
you also 6 months,
That is what.
1 day break, 6 months.
Immediately thereafter.
Immediately. I'm giving you immediately.
In fact,
But you don't complete more than 6 months because that is the requirement for your that regularization.
1993.
Raj Kamal
Yes.
scheme. That's the requirement. You don't complete for 240 days in a year so that you don't get that benefit. Whether it is seasonal or regular, matter remains 6 months. It is in that context that the Supreme Court has passed this order.
Where,
Next paragraph,
therefore, in the facts and circumstances, the members of the respondent have been employed in terms of.
and have been consistently engaged in service for 34 short breaks.
Union of
We
India
feel-
would consider enacting an
Short
appropriate-
breaks.
Huh.
Short breaks is not
Yeah.
synonymous with seasonal.
We feel the Union of India would consider enacting an appropriate regulation scheme for absorption.
That
of
is
regulation.
for the Union of India.
But what I'm trying to emphasize is once they come up with this scheme of 17th of September 2012, without differentiating, without bringing in that part of the differentiation of the establishment being a permanent establishment and works done by other casual employees of seasonal nature or of temporary nature. While classifying all the 90,000 together, my lord, they have violated Article 14 by classifying everybody together.
Go to you'll have to go to Supreme Court, get this thing clarified.
That liberty was granted when the contempt matter was taken up. That I have the liberty to bring in that aspect of the matter. At page 76, that is why, my lord, even while dismissing a contempt petition.
Now,
the Honorable
now,
Supreme Court
now
gave me liberty.
that note immediately after that judgment you tried to place before me. That note welfare, you come to page,
Yes,
para, page
72.
12, para 18 of that All India Trade Union Congress.
All India Trade Union, para 12,
Hmm.
my lord. It may not be necessary to elaborately deal with the issues arising in the case, but because we are of the view that the issue involved in this appeal is no longer reintegra and settled by the decision of this court in Union of India versus Vartak Labor Union. Well, this is the judgment that we did.
Hmm.
That was also a case of where the Union of India workers, namely Vartak Labor Union, had claimed a relief of regularization of service. Lordship will see it's a claim for regularization of service of the casual.
You don't want
workers.
a regularization.
Madam, no, the scheme that they had proposed to do, the scheme that the Honorable Supreme Court wanted them to make,
They made it.
that they made it. That scheme is what I'm trying to, they have rejected all 90,000 at a go. What I am saying is that that scheme, if it had considered that there were two classes of employees and then rejected us, we would have something to, we would have known about our fate. Here is a case where by formulating the scheme, following the Supreme Court's observations, they classify all of us into seasonal and temporary basis. The use of the term, the seasonal term, and that 90,000 employees are there every day in BRO. That is what is disturbing for the petitioners, madam. The proper consideration is what we want. The respondents, if they can say that the Eastern-based workshop or the other two establishments that we speak of which we are members, if these two establishments have not been there from 1961, if we have not-
Any other matter wherein, in this lot wherein you can contend that you are not a seasonal worker?
My lord, I have got only one another writ petition, my lord, that is WBC number 3873 of 17.
Hmm.
But from their pleadings, I find that they are seasonal employees in Arunachal Pradesh. Since
Your
they've
item
used
number
that
is, item number?
my item number is 7. Sorry, item
Nine.
number 9.
And
The
the
first-
second one?
Second one, my lord, perhaps, Miss B. Bhina was appearing, the senior advocate.
You are appearing in that matter now.
Yes,
I'm not.
11,
You're 11, you are there.
10, I'm not there.
10, what is the status?
3873, my lord, it comes up as Miss B. Bhuya, counsel for the petition and WPC.
These are master roll. These are seasonal.
They are seasonal, they are done there for only for the road work that goes on there.
And what about
That,
item number 10?
my lord, that I could not
Anyway,
like the rate. That is
we'll not rush into it.
Lordship, our contention here is
Not convinced,
we require to be.
not convinced. You require a little bit more hammering on me. Not convinced.
Lordship promised me to persuade more, my lord, on some other day. Persuade more on some other day, my lord.
I think naturally, because these people are,
What I'm trying to only emphasize is a proper consideration. Regularization, my lord, anyways, we cannot. say
you
that
are
we-
trying to make a class out of the class already identified by the Supreme Court. You are trying to make a subclass.
My lord, I'm trying to say that their notification does not notice that subclass.
1960 might have been.
In the meantime, I may have to try my luck at Supreme Court also, my lord, for a clarification as well. Yesterday, I had a.
Otherwise,
I had a
because
discussion.
when the word uses casual labor, it's synonymous with either your, and it says short breaks. Short breaks cannot be understood in the context of a seasonal worker.
Those seasonal labors which they now try to club us.
That's
together-
your context. But as far as I am concerned, the word, I'll have to go by the context in the word, the words I use. Word is casual labor.
Yes.
Casual labor with short breaks. So that cannot be deemed to be a seasonal worker. If the Supreme Court had that in mind, it would have spelled out.
What happened is when the matters.
See, there might have been two classes of people before the Supreme Court. Can't say. It may be possible. But the judgment that has come out deals with casual labor. You now cannot say that this will only relate to a seasonal worker when there is no distinction made.
Even, my lord, if I agree that, yes, there are no two classes, even then, when the Supreme
At least
Court has
agree.
given-
At least agree to that. Then we will proceed. You have been taking me round, 15 last 20 minutes only on this thing.
My lord, some other day, my lord.
Item number 9, 10, and 11. But Mr. R. Majumdar at length list this matters again on 7/3/2024 as a part-heard matter. It's not. You think about it. I made up my mind.
A little more.
You
margin, my
show
lord,
me something very conclusive that this is the only analogy that is possible. I'm with you. Otherwise, you're gone.
I'll try.
Mr. Bora, Mr. D. Bora, DC Bora, and CGC is present. We'll see.
I'll try again.
7th.
Obligation.
7 months. Mr. Bora, anything you want to say in this matter?
No, lordships, nothing.
You're accepting all those.
No, I'm not thinking, my affidavit will speak everything.
Establishments has been accepted by them in the affidavit.
My affidavit will speak everything, lordships.
You can keep this. Continue.
Obliged, lordship.
Yeah, I got Bora. Next case. I got Bora. Bora, job.
Where
Yes.
May I please, your lord?
Yes, Mr. Lutto. Oh, that. I think this will take some time, some hearing.
Lord,
It may not be possible. Only she's left now. We'll have it on 5th, 5/3,
5/3.
5/3.
Not on 5, let it be on 5.
Whenever it's gonna.
7th, my lord.
7,
7th.
7/3. On the prayer of the parties, list this matter again on 7/3/2020. But have you examined that issue?
Lordship, I.
What did you get? Just a synopsis, small. What do you get?
From the very beginning, my lord, from 2002, when the chief inspector has taken the inspector factories has come, taken his charge, and this person, he has taken the charge of additional as a temporary basis. The quarrel started.
No, quarrel is
And
different. But the damage which was done to you was not rectified. And they say, the ACR being given to you, you replying, and then a finding coming, then you can't claim that don't consider my ACR. That is,
I have to do that.
try to get something on that area.
No.
Yes.
create
It of wiggle. 26. 28, okay. Yes.
My lordship,
I
yes, lordship, IA is substitution lordship, already substitution lordship.
We'll substitute, don't worry. And then hear the matter.
Yes, lordship.
This interlocutory application has been instituted by the heirs of Sri Vishwa Soikya, writ petitioner in WPC number 100/2013, who during the pendency of the proceedings expired on 5/1/2024. The applicants herein are the sons and daughters,
Yes, Lordship.
are the sons and daughter of late Biswa Soikia, the original petition. I have perused the amendments made in the petition, in the interlocutory application, and as such, but this court has perused. I am minded this court has perused the so and so, and is satisfied that the petitioners, applicants have made out a case for permitting them to be substituted in the place of the original petition. Accordingly, this interlocutory application stands allowed. The applicants are permitted to substitute themselves as petitioners in place of the original petitioner in WPC number 100/2013. Okay, now you argue your main case.
Yes, Lordship.
Now we can hear it.
Yes, Lordship.
Hmm.
Lordship, we have in this matter, Lordship, the pertaining promotional benefit, Lordship.
Hmm.
So, Lordship, whatever, Lordship, I would like to point out, page 59, Lordship. Lordship is ever in this regard, Lordship. Page 59, Lordship.
Hmm. Okay, you do one thing. We'll first regularize this. The main petition of Likha, red petitioner. In view of the order passed today in IA number 440 of 2024, allowing about 440/2024. Gita, Nam Gita, Gita, apni ani boli. Anup Soikia, Rup Soikia, Sangita Soikia, and Rajiv Soikia. Page 3 and 4 are permitted to be substituted as petitioners in the present proceedings in place of Sri Biswa Soikia, who had expired on 5/1/2024. Full stop. The Learned Counsel for the petitioner shall file an amended cost title with the registry within 3 working days from today. So, list this matter again on 4/3/2024 for further consideration. Amended cost title, others this will not come in the CIS.
Yes, Lord.
File an amended cost title, let it come back.
Yes.
We'll consider on 4th.
Yes, Lordship. Much, Lord.
29.
Yes, Mr. Purkhasta, anything?
My lord,
Anything?
checked on, my lord, some decision, my lord.
You give me.
My lord, lordship, my lord, put a question that, my lord, delay in disposal of the matter, whether it will amount to waiver,
It will never amount to waiver. Don't worry about
whether
it.
it will amount to waiver,
It would not.
it would not.
It will not.
Therefore, my lord, for this or that
I
reason,
told you that day that I'm not concerned with the period from 2013 onwards.
my lord,
Explain the period
my
prior.
lord. Therefore, my lord, since the matter was initially filed in 2008, thereafter another petition 2011, they didn't consider our
These
case.
two are the facts, and the third fact would be as to the scope of this court
Yes,
passing orders today
Right.
after 20
22 years.
years. That much only.
Yes. Therefore, my lord, the lordship, my lord, basically, my lord, if what comes to the conclusion that though it is a matter raised to compassionate appointment, and once there is a direction by the court on 2 occasions to consider the case, they didn't consider. Later on, when we moved the petition, this was that matter is kept pending or because of some lapse on the part of the,
Anybody,
Anybody.
that's a forgone. Don't
Right.
forget that. That what has happened has
Right.
happened.
they.
Now
filed
just
their-
show me, Mr. Purkhasta, I just want your assistance to show this court that this court still has the power to make a direction. That much only.
Therefore, my lord, even despite the question of delay, if I can establish on fact, my lord, or on the face of the record, the decision they have taken and the way they have proceeded,
This is not, justifiable and beyond authority. Two ground, my lord, they took, my lord, two stand in their affidavit. Number one, overage, and the second will be no vacancy. These are the two grounds. My lord, facts means that, my lord, as it appears from the
How
relevant,
long will it take for you to conclude?
pardon, my lord,
How long will it take for you to conclude?
my lord, I will make a request, my lord.
Hmm.
And I was worried about my performance before this court, my lord. My lord, therefore, my lord.
Mr. Purkhaista, this court is no one to judge a performance of a
Therefore, my
seasoned
lord-
lawyer like Mr. Purkhaista.
My lord,
We look up to you to assist us.
my lord, therefore, my lord, since court expects some assistance on my part,
Naturally,
may I request, my lord? Yesterday, my lord, I could not prepare the case to that extent so that I can.
no problem. I'm not on a risk, but I want the assistance. I want you to show me that I have the power
My lord. Therefore, my lord,
in spite of the Supreme Court judgments.
my lord, may I request, my lord?
Yes.
My lord, kindly give me some more time, my lord.
When do you want it? Tell me. I'll fix the date as per your convenience.
In the month,
But after 4th.
yes.
Hmm.
Today,
No, after 4th.
oh, after 4, my lord.
Whenever you want it.
Just, I'm looking from it. Lordship, may I kindly fix the matter on 11th?
On the prayer of Mr. A.K. Purkhaista, counsel appearing for the petitioner, list this matter again for further hearing on 11/3/2024.
Therefore, my lordship, I will be obliged, my lord, if your lordship kindly, my lord, repeat the question, lordship wants to get an answer,
I want an answer whether after this, at this long distance point of time,
my lord,
whether this court has the power
my
to direct for consideration of your case for appointment and compassion.
my lord. On the basis of,
Because today the order is being
Madam.
passed.
on the basis of,
Whatever that circumstances is you to consider, but even under that circumstances, whether I have the power. That's all.
on the basis of factual situation of this case,
Factual situation of this case, the very
Whether court can
concept,
apply
no,
such a
Mr. Burkesa, very concept of compassionate appointment,
my lord,
the distant point today,
Madam.
and the reason that is
I'm obliged,
11th.
obliged.
Next. Now, it's really good.
22.
Yes,
Yes,
what is the,
Last time lordship had queried regarding the. After execution of the retirement date, whether the original clauses incorporated in the partnership is
Hmm.
valid or not, that's
Hmm.
what, lordship, I want to clarify, lordship, this is.
yes, Mr. Bhagan, what do you have to say?
My lord,
Last time it's,
the issue that is before your lordship, my lord, relates to the point that whether the agreement my learned friend is relying upon to invoke arbitration can be, my lord, invoked in the light of the fact that
Subsequent
subsequently
retirement date.
there has been certain important developments where the earlier disputes were resolved. And he being a signatory to those subsequent agreements and resolutions, now can he go back to that particular
Early one.
agreement of 2015, which virtually became redundant in the light of these new
Yes,
developments?
why do you say it is not redundant? In the retirement date, is there a partner, there is arbitration clause?
Yes, ma'am, there is no arbitration clause. Now,
the
my lord, may
requirement-
kindly allow me, if my lord friend would submit and my lord, he can submit.
he can submit.
Don't add to the confusion. This court is already confused. Huh?
My lord.
Okay. This judgment you want to rely upon.
Lordship, lordship,
Come to paragraph 8.
yes.
Yes. Yes, Lordship. On
There
the-
is no arbitration clause in the retirement deeds and
Yes.
therefore,
Yes,
see, the main agreement gets covered by it gets superseded by the retirement deed.
no, Lordship. Here cannot be.
If you have retired,
Yes.
that means
No, Lordship. Here-
well,
no.
show me the retirement deed.
Yes, that's the part, Lordship. Lordship, kindly go through the section 7.
No, you show me the retirement deed.
In the retirement, there is no.
No. I just want to see the nature of the retirement deed.
Yes.
Madam, may I kindly come to my affidavit?
Date of return 28.
Huh?
Page
28.
95 of my affidavit in opposition, my lord.
Affidavit in opposition by,
By respondent number 1, 2, 3, and 4. My lord can take up 1, 2, and 3.
Lordship,
At page 95 is the retirement deed.
what is the running page? You have the running page? No.
Running page, my lord, is
in
90.
those days, there is no.
95 is the running page, my lord. Internal page is 36.
Okay, running page is 95.
95, my lord.
95. Okay. Okay, deed of retirement.
My lord,
Page number 30, Lordship.
here we all are signatories, including my learned friend's client, my lord.
If we go by
And
the-
there is a mention of this at paragraph number at page 97. This retirement, where the retiring partner has given notice to the continuing partner for desired partnership bid so and so, my lord.
Lordship,
Just a moment. Yes, I have marked it. Para 4, 98.
My lord.
Yeah.
What is your name, Mr. Sharma?
Notoral Mishra.
Huh?
Notoral Mishra, Eastern Cargo Motors. We are representing on behalf of Eastern Cargo Motors.
Natwar Lal Mishra.
Notoral Lal Mishra.
That is the new partner.
That is the continuing partner.
Continuing
Continuing partner.
There is no new, Lordship.
Continuing partner.
Continuing partner.
Lordship, before going to
And
the-
where is your,
Lordship, kindly go to the Bear Act, clause 7.
just a
Section
moment,
7.
just a moment. What?
Lordship,
Correct. Read.
Here, Lordship, before that, Lordship, Lordship has referred to the deed of retirement, Lordship.
Hmm.
Here, Lordship, in my petition, Lordship, page number 31.
Hmm.
This is
What is the nature of your demand in the arbitration application? What is the nature of your demand?
demand is that they are using the vehicle, which is in my name. And as per-
No, tell me. This vehicle was there when it was a partnership firm?
Yes, Lordship. Yes,
So when this partner left, retirement date
Yes, sir.
happened.
Mhm.
How did this vehicle, how was this vehicle dealt with?
Lordship,
I'll come to that point, my lord.
Lordship, let me say, Lordship,
My
Yes,
lord, the vehicles which were in the name of the original company, my lord, it was decided in the deed of my lord retirement that the vehicles would now continue and we would not be paying the debts and the liabilities. The continuing partner would be paying the debts and liabilities of the old vehicles, which is clearly my learned friend has just mentioned in the clause, my lord, 4 of the retirement agreement. If your lordship may kindly come. He agrees to that he will continue to pay the debts and liabilities of
Yes.
the vehicles
yes,
of all movables. At page 98, my lord.
clause?
Clause number 4, my lord. If I may read, my lord. The continuing partners agrees to pay all the debts and liabilities of the said firm today and to indemnify and keep indemnifying retiring
So,
partners
okay, the
And
old
secondly, my lord-
vehicles will be with the company,
with the company.
continuing partner.
Yes, my lord. And kindly,
Right.
not continuing.
my lord, now, my lord, kindly come to clause number 13 at page 99.
Hmm.
At the time of retirement, MS Eastern Cargo Movers will hand over some of the movable and immovable assets to retiring partners, and the total valuation of those assets are 1 crore 84 lakhs.
Okay,
And details, sir.
okay.
Now the vehicles are handed over to us.
Fine.
Yes, my lord.
Where is the list of the properties that were, it's a movable or immovable property that were handed over to you?
Yes, now my lord may kindly come to the list, my lord. At page 102,
Hmm.
your lordship will see movable assets received by the retiring partner at the time of retirement. Your lordship has found at page
Five
one.
numbers of ultra truck, one
Yes.
number 10, so,
Yes,
so,
so
yes.
these 5 numbers of ultra trucks and
We
in
had heard this matter details, sir.
my lord has heard this matter on the last
That's
occasion.
why it's on voting, sir.
Lordship is not hard.
Only was,
Then I have read.
Really, yes,
Something is there.
yes,
Lordship.
Now it's clear to me, yes.
and then my lord may kindly come to page
Lordship,
number
here,
103.
my grievances is there, Lordship. They are using the name of Eastern Cargo Movers without transferring the vehicle in their name. That is my grievance. That for that we lose the original company lost. We have a great huge loss. For that's the reason we.
So tell me, this is not something which emanated from the original agreement?
Yes, original agreement. That's
One
that's
second,
I want to.
Soma, 1 second. This is not a dispute that originated from the original agreement.
That
1 minute. This original agreement, that vehicle was with the partnership firm.
yes.
This transfer occasioned only in the retirement deed.
Yes.
You agree to that? You agree to that? The transfer of that vehicle
Mm.
from the partnership firm
Yes,
to this individual
Yes.
occasioned in the retirement deed.
Yes. Okay.
So the original agreement or the partnership agreement has got nothing to do with. Has got nothing to do with it. This thing occasion, this dispute or this grievance occasions or has a beginning
Mm.
in that retirement deed.
Yes.
So the retirement deed, show me, where is that arbitration clause?
No arbitration clause, my lord.
In the retirement, there is no.
Because this decision,
Yes.
this is given by you.
Yes. Yes.
My lord, in fact, there is an admitted
decision. Here in this decision, Lordship, here in this decision. Lordship,
Okay.
In fact, it is an admitted position by my learned friend in his petition that I have violated clause 17 of the new retirement deed.
Okay, you mean to say that finding there in paragraph 15 that both should be read together?
Yes, Lordship. Here,
We'll
Lordship,
examine.
because the reason
examine.
behind the reason behind Lordship.
We'll examine, Mr. Very interesting. We'll examine. If that be the proposition that
Yes.
both have to be reckoned together,
Lordship.
then an arbitration clause would come in.
Yes, Lordship. That is the.
If it is to be reckoned in terms of 7.5
Regarding
of that act,
that part, Lordship.
then there will be two
Regarding
distinct.
that part, Lordship, whether reckon with together or not, that part we would argue for more than 3 hours in the court number 2. So, Lordship,
I don't have that much of capacity to hear.
he argued, Lordship. He argued to only 3
That was
hours
only
Lordship,
earlier.
together.
I don't have that much. 5 minutes, 10 minutes, if you
Yes,
can
madam.
make me understand, I'll
Here,
take the matters.
Lordship,
on
here, here, my contention is this, kindly go through my.
This is the issue.
Small issue, my lord.
Small,
This is the
Lordship,
issue.
kindly-
Very
Before that, Lordship, kindly go through my, just page number 30, Lordship.
Hmm.
Page number 30 of my section 11 petition, Lordship.
Hmm.
Here, whereas the parties here to have been carrying on business in the partnership under a deed of partnership dated so and so entered into by the parties and in the name of Eastern Cargo Movers, Lordship. Here in the retirement deed, there is a reference of the original partnership deed, Lordship. Original partnership.
Naturally, there has to be, otherwise how will you have a
Here,
retiring date?
Lordship, here, again, Lordship, in the original, Lordship,
One
page number
thing-
18, Lordship.
18.
18. Again 18, Lordship. That all the disputes, here that all here,
This again goes, come read.
here all their disputes relating to the partnership business between the partners or their representatives, it cannot be settled mutually.
Now you tell me, this partnership business, after the retirement date
Yes.
survived,
Yes, Lordship,
No,
that's
no,
the
how
case,
can-
Lordship. Here the crux of the case, Lordship. Here, if Lordship goes to the deed of retirement, deed contents, it,
partnership deed, partnership act.
no, Lordship. Here, partnership act, it is unregistered partnership form.
Oh, understood.
Not
Then
required.
it's over, my lord.
For this
Then
is,
it's over, my lord.
we are covered. the
Heard
form of-
the parties at length.
Lordship.
Heard the parties at length. List this matter again on 7/3/2024 for further consideration.
7.
3.
My lord, on that occasion, I would like.
Whatever it's you place it here.
Yes, yes, my lord, decision of the Honorable Apex Court, my lord, regarding whether my lord is having the power to decide on the maintainability of the issues that we have.
Yes,
raised
Lordship. Here
on
I also
Section
have
11 of this.
magic.
See, if there is an arbitration clause
Yes.
or an arbitration clause can be read into that retirement deed.
Yes, my lord.
Thereafter, I am not empowered to decide whether the issues are arbitrable or not.
Of
I
course.
will have to refer you parties to the arbitrator
Correct, my lord.
and the arbitrator will take forward.
Correct, my lord.
My only endeavor is
My lord.
that whether
Exactly, my lord.
there is an arbitration clause in
Clause or not.
existence,
Yes, my lord.
if that arbitration clause can be exhibited, demonstrated to be in existence,
My lord.
my power under 11.6 delegate, I'll use.
Yes, correct, my lord.
Otherwise, I'll close.
Yes,
That's
that is my humble submission, my lord.
And beyond that,
Beyond that, of course,
neither
my-
will I understand
of course,
anything.
my lord. Of course, my lord.
No, you can get anything.
Of course
inside.
not, of course. That's it. I'm highly obliged.
Highly obliged, Lordship.
Deeply obliged.
And if there is any other issue beyond that,
No, there's no issue, my lord, no. That can be arbitrated, of course, before the arbitration, my lord. Only this is the issue.
only the issue is
Whether
there is a clause.
clause or not, there's a clause or not.
Yes, Mr. Sharma, show me.
Okay, on 7.
And what is the judgment?
This is of 2022 SEC Online SC 896 Indian Oil Corporation versus NCC Limited, my lord.
For the proposition?
Proposition is regarding, my lord, that the point that my learned friend is raising, that this court do not have the power to deal with the maintainability issue.
Oh, no. That
This
is
is
settled.
covered in the NTPC and Magic Act, Lordship.
The latest decisions are there.
Yes,
We
sir.
can go into the issue whether there is an arbitration clause.
Exactly.
Otherwise, this court would become a post office only.
Yes, of course, with all due respect, my lord.
Give me that.
My lord.
I'm giving another judgment, Lordship. Magic Eye and NTPC Limited.
What you just write, Mr. Just write petition or respondent therein
Yes,
and
my
put it in the file.
To
Deal.
I've written the paragraph also, my lord. Only one
File to
paragraph
na lage.
relevant.
File to na lage. File e didio. By slip pothai diyo.
I'm highly obliged, my lord. Deeply obliged.
Yes, next. Pathak koi decision. 23, itu Pathak.
Regarding provincialization, my lord.
Yes, what happened?
In this case, petitioner was the private respondent who is junior to the petitioner, my lord.
Language.
Language, my lord. Both of them are language, my lord.
Why was you deprived? It's not file to.
No, my lord. She was appointed in the year 1998, whereas private respondent was appointed in the 2002, my lord. It's my lord.
First time approaching this court.
My lord.
File an appeal under 14. File an appeal under 14. Where is the DSC recommendation?
No, my lord.
Not on record.
Not on record.
Then how can we determine? If there is a recommendation now, file an appeal before the secretary. Let that reason come on record. We will then examine.
My lord.
It's your 21 onwards, this matter is here. Nobody has appeared. Then how can we? You proceed before the, rather than keeping this matter here,
Right.
today or tomorrow, whatever order we pass, we'll have to pass that. You go before the,
My lord.
exercise that.
Section 14.
Section 14. Withdraw this. I'll ask them to consider your case
No,
within
my
a
lord,
particular
that may be
period.
disposed with the direction.
Okay, dispose of. You'll get it by Friday.
My lord.
Dispose of. Your name?
Jai Laskar.
Hmm?
Jai Laskar.
Mr. Pegu. After a long time. After a long time. Your standing counsel, what is involved here? Elementary.
Limited.
Elementary. And all the 3 posts have been filled up.
4 posts filled up. my lord.
Headmaster given.
Headmaster given. my lord.
Headmaster,
The headmaster, 2 language teacher, and 1 science and 1 my lord. Yes.
language, 1 science and 1 social studies.
Social.
And you are, your only case is that you are senior to that lady.
My lord, that's one number 7.
Respond number
She
7.
was appointed in the year. 2000.
Nobody appears for respond number 7.
No, my lord, in spite of completion of service, she has not.
Because she knows she has a good case. You don't have a case.
My lord.
Okay. Now show me something. This is the document, page 21.
My lord.
Respondent number 7 is serial number?
Serial number, my lord, 3. Date of
And
joining,
petitioner?
petitioner at serial number 5, my lord. 14/9/1998, my lord.
MIL in what? MIL in?
Is Assamese, provincialized Assamese, assisted Assamese language, my lord.
Oh, you are a Hindi teacher.
My lord.
There is no requirement for a Hindi teacher there.
No, my lord, language is not defined, my lord. As per my lord, section 3, my lord. Language teacher.
Come to page 115. Okay, this will be with regard to that. Yes, Mr. Majumdar. What is the difference between Hindi and Assamese MIL, English MIL? Assamese, Hindi, English. Normally we know them as languages.
If it's an Assamese medium school,
Huh.
then the Assamese is a compulsory subject.
Hmm.
And the other two would be then languages, is what I understood.
That's true.
If it's a Hindi medium school, then Hindi
Hindi
is
will be
one of the compulsory subjects. The other two become the additional MI. When they say MEM, it means an Middle English Madrasa, where English is
See,
compulsory subject.
in section 4(2)(4).
Worship will permit me one.
115 page. Whatever, there he's, Mr. Pegu has got a book. 114.
My lord.
This is an ME school.
ME school, my lord.
Now you come to 4(2)(4).
In case of teachers or tutors of the schools for special subject like Sanskrit.
So it has not been included in the normal language subjects.
No.
But this is again specifically not for an ME school, it's for a high school.
High school.
High school, my lord.
So this prescription, we'll have to read it for. Not in this case, I just wanted to clear my cobwebs. How do you determine if there is two persons, a Hindi teacher and an Assamese teacher, or an English teacher? Hindi is senior. How do you choose? Is there any criteria in the rules in this connection?
No.
No.
Aleha, list this matter again on 5/3/2024. It will dispose the Habona. The Learned Counsel for the parties to the proceeding are to apprise this court as to the manner in which seniority is to be determined between a teacher in an ME school teaching the subjects like Assamese, Bengali, Hindi, Bengali, English, etc. on the one hand, and a teacher's teaching subjects like Hindi, Sanskrit, Arabic on the other end. So, Mr. R. Majumdar shall make his submissions in the matter on the next date fixed after having received necessary instructions thereon from the respondent authorities. Also, registry to reflect the name of Mr. R. Majumdar in the R. Majumdar Standing Council, Department of School Education in the cost title, cost list. List this matter again on 18/3/2024. If you are not standing somewhere, try to come down.
Right.
And take care of your knees.
May I please, Lord? My lord, before going to the merit of the case, my lord, I may allow to my lord make
Chancellor Secretary as a party respondent, my lord.
You want to file some application?
My lord.
No, no, no. What do you want me to do today?
My lord, the Chancellor, my lord.
You want to file some additional
Yes, my-
implementing application?
Yes.
लिखा है लिख लो लिख लो लिख लो भाई बोले the on the prayer of the petitioner on the prayer of the council for the petitioner list this matter after 2 weeks. The petitioner in the meantime may take steps for impleading other parties in the present proceedings.
Most obliged.
Obliged.
Item number given. List this matter after 2 weeks. On the prayer of the council for the petitioner. On the prayer of the council for the petitioner. List this matter after 2 weeks. On a date to be fixed by the registry. The petitioner is permitted to implead other parties in the proceedings. In the meanwhile.
Obliged.
22. Yes, next. ये तो 24. ये 24 है. 24.
25.
Yes, Mr. Bhuyan.
My lord, I have an instruction, my lord, that it's up to my lordships, my lord, but my lord, I have suggested not to press. And my lord, in future, my lord, it's appear, my lord, that on her merit, that may be considered that observation if my lord is to my lord.
Mr. A.R. Bhuyan, Learned Counsel for the petitioner on instructions has submitted that the petitioner does not desire to press this matter any further. Also heard Mr.
1, 2, and 3.
P.D. Nair, Learned Standing Counsel, Cotton University, and Mr. R. Mujumdar,
That's one number 4.
Learned Standing Counsel, Department of School.
My lord, no, I'm for the private response.
For the respondent number 4, main man.
Main man, my lord, and he has chosen a correct man also.
Correct man. How things fall into place.
My lord.
People who might be seeing may be thinking that Mr. Rajesh Mujumdar is the very bad man. They don't understand the banter we have. Also, accordingly, the prayer is accepted and the writ petition stands dismissed as withdrawn. However, the dismissal of this writ petition shall not be held against the petitioner if she participates in any future recruitment, and the case of the petitioner shall be considered in such recruitment on its own merits without being influenced by the dismissal of the present. I think that will satisfy.
My lord.
26.
Obliged. Obliged. My lord, this is that matter. My friend has filed a review petition, my lord, that has also been listed in the supplementary, my lord.
Today,
My lord.
for what?
My lord, for consideration of the review application, my lord.
No, you have filed a review.
No,
he has filed a review.
Copy, we did not get copy, your lordship.
You did not get a copy.
And
This is that.
Review.
Mr. S. Chaudhary, Learned Counsel
I'm
for
giving
the
copy.
review petitioner.
Just, I have a copy. my lord.
Today, it's not possible, Mr. Chaudhary. Saturday, we'll have it.
My lord,
Wait, he's also not being paid.
my lord,
Wait it, we'll finally decide this issue.
my lord.
No. Review में लिखना. Item number 33.
My lord, my small prayer is there, my lord. Till then, it has to be a.
No, we'll not.
Because.
Until and unless we don't apply our mind to your contentions, we'll not. Because this court, in the order just prior to the order that I passed,
My lord.
coordinate bench of this court has also said that on the next day, this prayer would be considered.
I'm not on that, my lord. I'm just.
Then we considered, maybe we are wrong.
I want to totally.
Maybe we are wrong. We are wrong.
My lord.
But how does it prejudice you. It's only an interim order. If he gets the money, he gets it, and if you are to be bought in, we will direct that you will be coming in from that date when the others have come in.
But he will take my seat, my lord. That is the only one.
No. That is that your apprehension?
My lord.
We'll clarify and we'll dispose of this repeated review.
My lord.
We'll say that interim order cannot be deemed to have vested a right in him to claim that post without a conclusion arrived.
My lord, that'll do.
That'll do. Lekha, reviewed. Heard Mr. S. Chaudhary, Lanka Council for the petitioner, review petitioner,
7 of it.
and
46.
Ms. Pidas
He does.
for respondent number
SSA.
1, 2, for opposite part respondent number 1, 2, 4, 5. 5. SSA,
SSA.
Mr. Also heard Mr. S. Bora, Learned Standing Council, SSA Assam, for the respondent number 3.
P Nayak is appearing, your lordship. P Nayak is appearing
Oh,
for SSA.
okay. You are appearing for?
I'm appearing for P Nayak, your lordship. for
You are not
SSA.
appearing for the department.
Department.
Heard Mr. Also heard Mr. R. Majumdar, Learned
Elementary.
the district, the Learned Standing Council, Department of School Education for 1, 2, 4, 5. Also heard Ms. Pidas appearing for
Respondent number 3.
Mr. P. Nayak, NAYAKD. Nayak, Learned Standing Council, SSA, for respondent number 3. Anybody for respondent number 6? Mr. P. Soikia, no. This is school. Mr. 6, anybody for 6?
In the petition only, not in the review, Lord.
Whatever it is, your same thing.
Yes, Lord.
You are for your name?
AD Chaudhary, Lord.
AD Chaudhary, Learned Council, appears for the respondent number 6, whereas Mr. A.R. Bhuyan appears for the respondent number 7 oblique writ petitioner.
My lord.
Mr. P. Soikia has entered appearance on behalf of respondent number 8. The present review petition is instituted praying for a review of the order dated
12-1, my lord.
12/1/2024, by which this court, on consideration of the issues arising in the writ petition, had directed that the respondent authorities in the elementary education department to release the current salaries of the petitioner forthwith from the month of December 2023 and payment to be made to the petitioner within 10 days. So it was further observed, further directed that the salaries of the petition shall be released regularly with effect from the month of January 2024 until further orders of the court. It is the apprehension of the review petitioner that by virtue of the petition, by virtue of the opposite party respondent hearing, respondent number 7, receiving his salaries, the provincialization as made in his case gets confirmed, and that would be to the prejudice of the review petitioner. Full stop. It is clarified that the order dated 12/1/2024 as passed in WPC number 5620/2022 was only passed as an interim measure, and the same shall not confer any right on the petitioner to claim that the provincialization order passed in his case has attained its finality. The provincialization order as passed in case of the petitioner is subject to the final adjudication that would be undertaken by this court in the writ petition. Full stop. In view of the said clarification, the apprehension of the review petitioner is redressed, and accordingly, the review petition stands dismissed.
My lord, the salary they will pay me, lord.
Yes, that day she said that she has already released your.
No, lord, it's a wrong information process.
Come with the
is going
contempt.
on. My lord.
Come with the contempt.
My lord.
My lord, as your lordship has heard the matter, can it be fixed or is it passed out matter?
No. A writ petition will release this matter again after 2 weeks on a date to be fixed by the registrar. So your apprehension is gone. Then
My lord,
you told me that this on the last occasion only, we would not have carried this file.
My lord, the interim order passed in the writ may continue, my lord.
The interim or writ mein likhna, writ petition, the interim order passed earlier to continue. And that's a continuing order, Mr. Bhuya. That every month you will have to pay your salaries. There's no requirement.
My lord, my lord.
27.
Oblige, madam.
Oblige, lord.
Second of November, November. Mr. Sokia, the service on respond number 3 is not complete.
Notice has been served, I think, and
3.
newly imputed respondents, my lord, notice was served.
When? When was it served?
And I think they have appeared also. For this.
Anybody appearing for the respond number 3 here?
Respondent.
Their names are reflected, my lord.
Names are reflected.
Yes.
Oh, then it's okay. No. 1 and 2.
In this case, my lord, only the commissioner did not comply because the director has written a letter complying the judgment of the scope. We have that letter. We have annexed in the IO. But the commissioner is sitting silent. I have annexed the letter of the director in the IO. IO was filed, which was disposed of.
Okay, Mr. Okay, I got it. Yes.
My lord,
Why orders have not been passed?
No, my lord, in compliance of the order dated 16/3/2022, regional order has been passed, my
Show
lord.
me.
Here it is regional order.
You show me. That's what only we require. Mr. Sokia,
My lord.
they have passed the reasoned order. And that is the only requirement in the act, in the order.
I have not got it.
You will get it.
Yes.
We'll give it to you.
What order is passed? Let me go through and the case will be taken up, my lord, in the next.
Nothing is there. You make a challenge to this. Now we can't because you come to page 10
Of my contempt petition.
of the contempt petition.
Yes, yes. Okay,
10 para 6.
just a minute. Go ahead. Take it over.
No. This is not compliance. This is no compliance. What is this? I have sent it to the government. The government will give, then I'll give. What is this? On the next date fixed. Mr. U. Sharma shall place before this court the response of the Secondary Education Department to the proposal put up by the director for ex post facto retention of the post held by the petitioner on 3/2/2020. Also. List this matter again on 6/3/2024. A copy of the order dated 18/4/2023 as produced by Mr. U. Sharma is kept on record and marked as X for identification. This is now no compliance, Mr.
And being 18.
Mr. Sokia,
My lord.
let's see what we do now the next
My lord, I oblige.
time. Baki we go. Yes, Mr. Barabian, what is here? Motion?
Motion, my lord.
What is the case?
My lord, petitioners are brought to the old pension.
No, you'll not get it. Now that judgment in Purnima Hore is there.
They are, my lord,
That will hold the field, mister.
they are already got, my lord,
They have got.
What, my lord?
Then
They
what
are
is the
paying
problem?
for incremental benefit, my lord, page 59, my lord.
Why? How incremental benefit will come? That period only will come in. That period benefits will not come in.
My lord,
You show me in the earlier judgment that the period benefit has to be given. It is only for
Well-
computing your period of service that will be taken into account.
Page 59, my lord, order passed by the AG, taking the petitioners, my lord, under old pension. But I beg to refer, my lord, one order as per the judgment of this honorable court regarding OBB teachers, my lord, they are given the benefit, my lord. My instruction is that, my lord.
You, Mister, you are covered by a judgment in that, what is that name, that case?
Jivan Chandra Deka.
Jivan?
Chandra Deka, my lord.
Jivan Chandra Deka. You're covered by that judgment.
Yes, my lord.
Show me in that judgment that the period incremental benefits have to be given. We are dismissing it.
My lord, I kindly, my lord,
We are dismissing it. Then you show me others immediately. Just frivolous petitions.
my lord, this is page 15, my lord.
Page 50.
15, my lord. Jivan Chandra Deka.
No. You show me that Jivan Chandra Deka required you. You have been given that period of service,
Yes, my lord.
calculated.
Yes, my lord.
When was your thing provincial? When were you adjusted? Where is your adjustment order?
My lord, adjustment order,
Hmm.
one order, my lord, next page 34, my lord.
Date.
This
Ah.
is-
So this order is of 14/7/2011.
Yes, my lord.
Now you have been given that service from the date the school was provincialized.
Recently,
That
my
is why you came within the provisions of the rules of 1969. Otherwise, you would have been under the new pension scheme.
lord. Yes, my lord. My lord,
Now, that is the only thing you will get.
And,
Now show me from Jiban Chandra Deka that even the increment. Let's also learn. Come on, show me.
my lord, this is page 18, my lord.
18.
Page 18, relevant portion, I am, my lord, I beg to show directly, my lord. Last one, my lord, Roman 6, all appointments made would be prospective, but
You are reading?
page 18, Roman 6, all appointments made would be prospective, but will carry the benefit of past services for the purpose of computation of pensionary benefits.
So that past period, otherwise you will have 10 years of service. Now you'll have 20 years of service. Beyond that, nothing, because the appointments are prospective.
But next,
Today.
I will take instruction. I will withdraw, my lord.
Today.
But today, I may withdraw, my lord, this petition. Kindly, my lord.
No.
I
2 o'clock.
suggest them, my lord, kindly.
I'll sit for you. 2 o'clock. But these
Well-
petitions are frivolous. Will
Kindly,
not
my
permit.
kindly, my lord, next week, my lord.
List this matter again on 4/3/2024.
They are, my lord, showing one order, therefore, my lord,
4/3/2024.
diploma, my lord.
File some petitions where there is
Well-
something, but Jiban Chandra Deka is totally
Well-
against you.
My lord.
It
Limited,
never contemplated that
my lord, only pension.
period.
Pension, what is it?
Take care.
My lord.